What would you do right now if a cop looked you dead in the eyes and said, "Step to the back of the vehicle" during a traffic stop? Most drivers immediately comply without saying a single word, and that one silent mistake opens the door to a full search, an arrest, and evidence that can be used against you in court. Hit subscribe right now, because what I'm about to show you could be the difference between driving home tonight or sitting in a holding cell. These tactics are 100% legal. They come straight from Supreme Court rulings, and cops are trained to hope you never find out about them. Here's what you're about to learn in this video. First, the exact sentence you say before you move even 1 inch when a cop tells you to step to the back. Second, the magic question that legally forces an officer to show his hand before he does anything else. Third, how to protect yourself from a consent trap that is designed to look completely harmless. And fourth, a real traffic stop walkthrough that shows you the wrong way and the right way side by side, so you can see exactly how fast things go bad or how fast you walk free. This is not theory. I've analyzed over 200 body cam videos, and the difference between the drivers who go home and the drivers who get arrested almost always comes down to the first 30 seconds of that conversation. What you say and what you do not say in those 30 seconds is everything. So lock in right now, because this is going to change the way you handle every traffic stop for the rest of your life. Let's talk about why this moment is so dangerous. You get pulled over, the officer comes to your window, he takes your license and registration. So far so good. That part is normal, that part is required. But then something shifts. The officer asks you to step out of the vehicle, or specifically says, "Step to the back of the car." And here's the reality. That is not a casual request, that is a deliberate tactic. When you step to the back of your vehicle, you are now away from the car, you are in a more vulnerable position, and the officer can now observe the interior of your vehicle from a completely new angle. More importantly, once you are standing at the back of that car, the dynamic changes. You feel more exposed, you feel more cooperative, and most people start talking, they start explaining, they start volunteering information they have no obligation to share. That is exactly what the officer is counting on. Most people have no idea they are walking straight into a trap the moment their feet hit the pavement behind their bumper. So what do you say? Let me show you exactly how to handle it. The first tactic is called the clarification demand, and it stops everything cold before you take a single step. When an officer tells you to step to the back of the vehicle, most people just open the door and start moving. They do not ask why, they do not say anything, they just go. And once they are back there, the officer is asking questions, looking in the car, and building a case. Here's exactly what you say instead. You stay calm, you stay polite, and before your hand even touches the door handle, you say this: "Officer, am I being detained or am I free to go?" Those exact words, word for word. Write them on your hand if you have to. Memorize that line right now. Here is why those words are so powerful. They force the officer to make a legal decision on the spot. If he says you are free to go, you politely thank him and you drive away. Done. If he says you are being detained, he now has to have a legal reason for that detention. He cannot just say, "Because I said so." He needs reasonable articulable suspicion that you have committed, are committing, or are about to commit a crime. That is a legal standard straight from Terry v's Ohio, and this comes straight from Supreme Court rulings. Without that, keeping you there is an unlawful detention, and anything found during that detention can be thrown out of court. Bad way. The officer says, "Step to the back," and you say, "Okay," and you get out. Now you're standing behind your car in the dark, and the officer is asking you where you're coming from, where you're going, who you were with, and suddenly you are in a full interrogation you never agreed to. Good way. The officer says, "Step to the back," and you say calmly, "Officer, am I being detained or am I free to go?" Now the officer has to think, he has to justify what he is doing, and if he cannot, you leave. Former police officers have confirmed this works, and defense attorneys use this exact line in court every single day. Have you ever been asked to step out of a vehicle during a traffic stop? Drop a comment below right now and tell me what happened, because I read every single one, and your story might help someone else watching this video today. The second tactic is what I call the no consent declaration, and it is the most important sentence you will ever say at a traffic stop. Here is the situation. You asked if you are being detained, and the officer says yes. Now you are stepping out of the vehicle. That is legal. In Pennsylvania versus Mims, the Supreme Court ruled that officers can order drivers out of the car during a lawful traffic stop. So you do step out. But here's where everything changes, and here's where most drivers completely destroy themselves. The officer says something like, "Do you mind if I take a quick look in your car?" Or he says, "I am just going to check real quick." Or he uses your first name and says, "Look, man, I am just trying to help you out here. Can I look in the bag on your back seat?" It sounds harmless. It sounds casual. It is designed to sound that way. And 95% of drivers say something like, "Yeah, go ahead." Or, "I mean, I guess so," or "Sure, I have nothing to hide." The moment those words come out of your mouth, You have given up your Fourth Amendment protection against unreasonable searches. It does not matter if the search turns up something or nothing. You consented. And in the legal world, consent is a complete and total waiver of your rights. Here is exactly what you say instead. You look at the officer directly, you stay calm, and you say this: "Officer, I do not consent to any searches." That is it. 7 words. Say them clearly, say them politely, and do not say anything else after. You're not being aggressive. You are not accusing the officer of anything. You're simply exercising a constitutional right that every single American has. Here is the reality. Legal experts agree this is your strongest protection at a traffic stop. The officer cannot punish you for refusing consent. He cannot legally extend the stop just because you refused. And if he searches anyway without a warrant or without another legal justification, that search is illegal and the evidence can be suppressed in court. That means it cannot be used against you. This is 100% legal, and it has been upheld over and over again in courts across this country. Bad way. The officer asks, "Can I look in your car?" And the driver says, "Sure, go ahead." The officer finds an old pipe in the glove compartment. Now the driver is in handcuffs over something he did not even remember was in there. Good way. The officer asks, "Can I look in your car?" And the driver says, "Officer, I do not consent to any searches." The officer now has a choice: get a warrant, find another legal justification, or let the driver go. Without consent and without another reason, the car does not get searched. The third tactic is called the silence shield, and it works hand in hand with everything you have already learned. Once you have asked if you are being detained, and once you have said you do not consent to searches, the next thing that trips people up is the conversation that follows. Because officers are trained to keep talking to you. They ask where you are coming from. They ask if you have been drinking. They ask about the smell or sound or something they claim they noticed. And they are very friendly about it. They are trained to be friendly about it. Here's the trick they don't want you knowing. You do not have to answer questions that go beyond identifying yourself. In most states, you are required to provide your name, your driver's license, your registration, and your proof of insurance. That is it. Everything after that is voluntary. And the moment you start explaining yourself, you start building a case against yourself. Here's exactly what you say when the questions start coming. "Officer, I'm happy to provide my license and registration, but I am choosing to exercise my right to remain silent beyond that." Say it once. Say it clearly. And then stay quiet. Do not fill the silence. Do not explain. Do not apologize. Silence feels uncomfortable, but silence cannot be used as evidence against you. Words can. Watch what happens when drivers who know this tactic use it. The officer loses the ability to build a case through conversation. He cannot twist your words. He cannot use your explanation against you. He has to work with what he actually has, which in most traffic stops for minor violations is absolutely nothing. Listen closely because this is critical. I've analyzed over 200 body cam videos, and in case after case, the thing that escalated a routine stop into an arrest was the driver's own mouth. Not the drugs that were found, not the warrant that came back. The driver's own words. People talk themselves into handcuffs every single day. The silence shield stops that from happening. This is 100% legal. The Fifth Amendment gives you the right to remain silent, and you do not have to be under arrest to use it. You can use it right there on the side of the road during a routine traffic stop. Most people already clicked away from this video. If you are still here, you are in the top 10% of drivers who actually take their rights seriously. Drop a comment right now that says, "I am still here, so I know you made it this far." And so other viewers can see how many people are showing up and doing the work. Now, let me give you the legal framework that backs all of this up, because knowing the case names gives you even more confidence when you are standing on that roadside. Terry v. Ohio from 1968 is the big one. In plain English, it means police can stop and briefly detain you if they have a reasonable suspicion you are involved in criminal activity. But reasonable suspicion has to be specific and real, not just a feeling, not just because you look nervous. There has to be something concrete. That is why asking if you are being detained forces the officer to have an actual answer. Florida v. Bostic from 1991 is another critical one. In plain English, it confirmed that you have the right to refuse consent to a search. The Supreme Court said that a reasonable person must feel free to decline officers' requests. That ruling is the backbone of the no consent declaration tactic you just learned. Rodriguez v. United States from 2015 is the newest and one of the most powerful. In plain English, it means officers cannot extend a traffic stop even by a few minutes without reasonable suspicion of additional criminal activity. The stop ends when the purpose of the stop is finished. After the ticket or the warning is written, you should be free to go. They cannot keep you there fishing for a reason to search. This comes straight from Supreme Court rulings, and it is your protection against being held on the side of the road while they wait for a drug dog. Now, let me show you a real scenario so you can see all three tactics working together. You are driving home on a Friday night. You get pulled over for a broken taillight. Totally routine. The officer comes to your window and you hand over your license and registration. So far, so normal. Watch what happens with the wrong approach first. The officer says, "Sir, can you step to the back of the vehicle for me?" The driver says, "Sure, no problem." He gets out, walks to the back. The officer starts making small talk, asks where he is coming from. The driver says, "I was just at my friend's house." Officer asks, "What were you doing there?" Driver says, "Just hanging out, nothing crazy." Officer asks, "Have you had anything to drink tonight?" Driver says, "I had one beer like 3 hours ago." Now the officer has something. He says, "Well, I'm going to need you to do a field sobriety test." One answer led to another, and now the driver is on the side of the road doing tests he could have avoided completely. The driver fails, gets arrested, and it all started because he answered a question he had zero obligation to answer. Now watch the right way using every tactic from this video. Same stop, same broken taillight. Officer says, "Step to the back of the vehicle." Driver says calmly, "Officer, am I being detained or am I free to go?" Officer says, "You're being detained while I run your information." Driver says, "Understood," hands the officer his documents and steps out of the car. Officer comes back and asks, "Can I take a look in your vehicle real quick?" Driver says, "Officer, I do not consent to any searches." Officer then asks, "Where are you coming from tonight?" Driver says, "Officer, I'm choosing to exercise my right to remain silent beyond providing my documents." Officer writes the ticket for the tail light, hands it back, and the driver leaves. No search, no interrogation, no arrest. Just a ticket for a broken light and a drive home. Same stop. Completely different outcomes. The only difference was what the driver said. Next week, I am dropping a video on exactly what to say when a cop claims he smells marijuana coming from your vehicle. That is the #1 tactic police use to justify a warrantless search, and it gets people arrested every single day. Subscribe right now so you do not miss it, because that video is going to be even more important than this one, and I do not want you in that situation without the right words. Let's wrap this up quickly. When a cop says, "Step to the back," you say, "Officer, am I being detained or am I free to go?" before you move a single inch. If you do step out, you look the officer in the eye and say, "Officer, I do not consent to any searches," the moment a search is mentioned. When the questions start coming, you say, "I am choosing to exercise my right to remain silent beyond providing my documents." And then you stay quiet. And you now know the 3 Supreme Court cases, Terry v. Ohio, Florida v. Bostic, and Rodriguez v. United States, that back every single one of these tactics up. These are your rights. They were given to you. All you have to do is use them. Hit subscribe so you catch next week's marijuana smell video, because that one is going to hit different and you need it before you ever get pulled over again. Smash that like button if this just opened your eyes. And drop a comment telling me which one of these 3 tactics you are going to use first, or tell me about a traffic stop where knowing this would have changed everything. Stay safe out there, and I will see you in the next one.